timing. She filed a charge, an administrative charge, in July of 2013, and then she said, or 2014, and then that same month she gets her performance evaluation, and she claims that that somehow that temporal proximity is.
Does she claim that she's always been more or less the same in terms of her absenteeism?
She had a sentence in her declaration that had no facts, it had no hours, and it did say, basically, my leave has always been the same. That's not enough. The reason that her performance
why is that not enough?
It's not enough because it's not specific evidence. It's just
it's a very straightforward statement.
It is a very straightforward statement, but the standard is that in order to show pretext at the stage where the employer has articulated a legitimate business reason, you need significant, substantial, specific evidence.
Well,
and just
who has the records in terms of her attendance?
She has the records in terms of her attendance. So there was no reason why she could not.
How do we know that? Does EBMUD have the records of her attendance?
Yes, and there was exhaustive discovery in this case, and at the time that these motions were filed, she had access to her attendance records.
And did anybody put those in, including EBMUD?
I
should have thought if they would support you, you would have put them in.
Her attendance records are in the record for the time period at issue.
No, I'm talking about the earlier period, because somebody can be written up for something that they've been doing all along, and all of a sudden the hammer comes down when it could have come down before, but only for some reason only comes down now after they've made a complaint.
That is.
I mean, that's the argument.
That is the argument, and that's possible. But what did not happen in this case was that Ms. Rivera did not put in anything other than a sentence, a conclusory sentence, stating my leave was the same. What she didn't put in was her.
Let me make sure I ask the question.
Mm-hmm.
But EBMUD has her employment record in terms of her attendance, right? For the earlier period as well as the later?
It does.
And it chose not to put him in front of the district court to contradict the statement?
It did not, because this was a summary judgment motion. So in her opposition, she puts in this.
I should have thought that if the records were available to EBMUD and they would have disproved her statement that I've been doing the same attendance all along, that EBMUD would have put him in.
Except she made the statement in opposition, and you can't put in new evidence on a reply.
I see. So the first time she makes that, okay.
I would like to move on to the discrimination.
And are those records that you claim you have? And I assume you're claiming that they disprove her, or are you making that claim?
No, I'm making the claim that based on the records, those records are not in the record as far as I recall.
So you don't know one way or the other?
I don't know one way or the other. But what I do know is that she does not dispute that her leave was what it was that led to her getting the unsatisfactory rating. I want to move on to gender. There are the court did not confuse the standard that applies to the Equal Pay Act and to the discrimination claim. Under the Equal Pay Act, it's pretty obvious, and I don't want to belabor the point, that you can't just say, I'm a supervisor, she's a supervisor, therefore there's a common core of tasks, and you can't ignore the fact. I mean, think about, could Ms. Rivera go in and supervise electricians one day? Could she write them performance evaluations? Could she tell you whether she was doing the job? Under Title VII, the reason that Ms. Rivera can't articulate that she was being treated differently than similarly situated males is she can't ignore the existence of Stuart Gustafson, the other person who held her same position, who was a male. Because there was a male holding the same position she had, she can't argue that some circumstances indicated discriminatory intent. The district court did not get those standards incorrect. Denying her request for reclassification, what Ms. Rivera fails to point out is that she stopped the process herself. It's true she asked for a reclassification. It's true that one didn't happen. What's also true is that the reason it didn't happen is that she decided not to fill out the form. It's not true that her supervisor told her he was not going to participate in the process.
But is that a tribal issue of fact? And it seems to be conceded, or at least not in dispute that she didn't fill out the form, but the argument I heard was she sort of did the equivalent of that.
But she did not do the equivalent of that. And the point, what the form shows is that she needs to go forward and say, here are all the duties that I think I need to do in order to be reclassified. Then the supervisor responds to that. So she can't just bail out of a process and say, I don't need to do that. Mr. Lamb is not responsible for reclassifications. He is a supervisor. HR handles reclassifications. So to the extent he may have said that he thought it worked a certain way, that's not pretextual. That's him not knowing how reclassifications work.
Okay, thank you.
Thank you.
May it please the court. My name is Kerri-Anne Steele, and I'm counsel for AFSCME Local 444, appellee in this case. We ask that the court affirm the district court's grant of a 12B6 motion in favor of AFSCME Local 444 without leave to amend.
Can I
For at least 3 reasons.
Didn't the court make a fundamental mistake in basically coming out with the wrong black letter rule that unions, because they're not employers, can therefore have no liability? Isn't that just false as a matter of law?
There is a misstatement of law and a footnote, and what the court from the entirety of the order is attempting to express is that individuals cannot be liable under Title VII, and then there's a citation to the Miller versus Maxwell Incorporation case. Now, at that moment in the decision, when the court wrote that in a footnote, there were claims being considered of discrimination and retaliation under Title VII as well as EPA. In paragraphs 100 and 101 of the first amended complaint, those are alleged against a number of defendants. EBMUD as an entity, AFSCME Local 444 as an entity, and a number of individuals. That footnote dismissed the individuals. It should have said that there's no liability against individuals. We think that omission of the word individuals in the footnote is a mistake that could be overlooked. It was dicta as it pertained to AFSCME Local 444. The decision then proceeds to analyze the entities that are remaining to be considered for Title VII liability, and that would be EBMUD as an entity, AFSCME Local 444 as an entity, and there's discussion of the failure by the plaintiff to plead any claims that constitute.
Sure. So the normal default is leave to amend.
No leave to amend would be appropriate. If you look at the entire order, there's already discussion by the court, Your Honor, in earlier passages about how AFSCME Local 444 is a union, not an employer, and it does not decide who's a supervisor. It does not have.
But it has the ability, doesn't it, to intercede, to request reclassifications, to do all the functions that a union can do when you have I assume, a collective bargaining agreement with negotiations between both sides?
In this civil service system that EBMUD has, the classification plan is designed by the employer. This is pursuant to the authority of the Public Utilities Code. They have civil service rules that spell out the classification plan and how it will operate, as well as how to study whether a current classification is appropriate.
There's no possible way, so essentially any leave would have been futile.
Yes, and so what we're asking this court to do, which was an earlier question posed in a case this morning, is to look at that footnote as what it is, which is merely a misstatement of the law because there's an omission of the word individual before the statement defendants. And then to look further and say, on the face of this complaint, the First Amendment complaint, there is no possible way that claims of Title VII discrimination or retaliation could be stated against AFSCME Local 444. It was not in a position to be able to change Ms. Rivera's status. That is something that is done through a reclassification request through the Human Resources Office. This was not about a provision that is in the memorandum of understanding, in other words, the collective bargaining agreement. That would be the domain of the union and something the union could
Can't
be
have
involved in.
discrimination if you fail to even, for a discriminatory reason, pursue the rights of the plaintiff on the basis of gender, for example.
Not where, like here, there is access exclusively by the employee to the procedure, not by the union.
Just to be clear, if an employee went to the union and said, I think I'm being misclassified, can you help me? The union would say, there's nothing we can do for you, go talk to HR.
I'm not saying that that would be their practice and that there is necessarily a history of that happening here. What we are saying, and on the face of the complaint, it's evident that, and now through the developed record, it's confirmed that it's the employee's right of access to that procedure. The union is not involved. It's not a subject under the collective bargaining agreement. And certainly the union has no ability to determine whether someone's a supervisor.
You may not have the ability to determine it, but I understood her complaint to be suggesting that, or the proposed amendment to the complaint maybe, to be suggesting that the union would be able to pursue a grievance or do something to help the employee, and that if they were doing that on behalf of male employees who complained, but not on behalf of her, that would be the allegation she was making. And you're saying that there isn't anything meaningful that the union would be able to do to help an employee in that
That is
situation.
what I'm saying, Your Honor, that there's a fundamental misunderstanding of what the union can do in this particular instance. And on the face of the complaint, it's clear that no amendment could have salvaged her claim. It would be futile to do so at this point. So we ask you to please affirm the order. We also ask you to grant our request for judicial notice because it is important to see those civil service rules showing exclusive access by the employee to the reclass procedure. And they also contain the memorandum of understanding that show that the employee has no right of recourse under the collective bargaining agreement. Do you have any more questions for me? I'm out of time.
I think not. Thank you very much.
Thank you.
Response.
So let me briefly address the union's arguments. On this record, there is no question that plaintiff is entitled to leave to amend to assert her claims. If you look at her original complaint that was dismissed, she absolutely has plenty of allegations in there to attack the union's conduct with respect to her gender discrimination and retaliation. And as we know from the record that is now developed, it is false that the union does not have power to engage in reclassification attempts. It's in the record that it has the authority to work with the district and with Local 1 to make that happen, and it has done so. So on that issue, certainly the order of the district court needs to be remanded, and Plaintiff Rivera needs the opportunity to appropriately amend to bring the union back into the case.
Could you respond to what we heard with respect to retaliation from the other side?
Yes, Your Honor. So Judge Miller gets the analysis correct. District gets the analysis wrong. This adverse, they're attempting to graft an adverse action standard onto the retaliation claim, and it is clear under Supreme Court jurisprudence that the conduct has to dissuade a reasonable worker from making a charge. That's the issue. So when you look at first the Turner memo, obviously a memo after making a complaint that suggests that your supervisory duties are going to be taken away from you would dissuade a reasonable worker from making a complaint. You also then look at the attendance issue, which Your Honor brought up. It is true that there is no contradictory evidence in the record. What we have is Ms. Rivera's statement saying, I had basically the same amount of leave before and after, and then I was treated differently. It's not true that the district didn't have an opportunity to put evidence in. If there was new evidence offered on the opposition brief, district courts routinely allow responsive evidence in a reply brief. The district failed to do that. So that is a question of fact that has to go to the jury. And her statements are specific and substantive evidence with nothing to contradict. And those are just simply questions that a jury must resolve. They're not questions that can be resolved on summary judgment.
I think you might have misstated. You said there's no evidence that their attendance record was the same. I think her statement is itself evidence. There may be better evidence in the sense of the records, but her statement is, of course, evidence.
I'm sorry, Your Honor. Yes, her statement is evidence that it's the same. The district court did not. The district did not rebut that evidence by putting anything in to show. No, in fact, to their argument, no, in fact, the attendance issues were woefully worse afterward.
Right now, I just heard this morning that she has the better evidence of her actual attendance records. How do we know that?
We don't, Your Honor. We don't have it. There's nothing in the record to suggest that she has the records. The district doesn't have the records.
In the ordinary situation, somebody shows up at work and does not keep time cards at home and check off, I went to work at 8 o'clock and I came home at 5.
Correct, Your Honor. It's
So
not.
I'm not unless I've got more evidence that she has the records than simply the statement of counsel, I'm not convinced that she does have the records.
There is nothing in the record one way or the other on that, Your Honor. And then with respect to this audit form, again, that's a triable issue of fact, and just the argument I think really supports that this is an issue a jury needs to resolve. The fact that Superintendent Lamb isn't in HR doesn't change the fact that what you have in the record is Ms. Rivera complaining directly to HR in writing and requesting classification, and then going to the board to do so. So to say that she wasn't noisy about her request would be a gross misstatement, and it clearly presents enough evidence in the record that a jury would have to decide if the defendant's argument that she didn't complete the right form and that's why reclassification didn't occur, whether that is pretextual.
Okay, thank you.
With that, I'll leave it. Thank you, Your Honors.
Thank both sides for their helpful arguments. Rivera versus EBMUD submitted.
Hi, you just looked at the Rivera versus EBMUD video clip that was taken in the Ninth Circuit Court on December the 6th, 2019. I am videotaping it onto my YouTube channel in the event that the Ninth Circuit deletes these videos after a certain amount of time. I'm also going to be videotaping the clips in segments. I'm going to have the first video clip be of my attorney speaking, the second video clip be of EBMUD providing their position. The third videotape is going to be of AFSCME 444 attorney presenting their opinion or their position, pardon me. And the fourth clip will be of my attorney providing a rebuttal to EBMUD and the union attorney. Thank you.